everyone, my name is Haley Burridge. I'm a 3L law student at Loyola University Chicago School of Law. And along with my partner, Cruz Rodriguez, we will be discussing Election Day in 2020, the challenges to voting and voter laws.
We are going to begin by discussing one of the biggest voter suppression tactics that are used by individual states in the United States. These are voter ID laws. Voter ID laws require that a voter present some sort of identification to be able to cast a ballot in an election. The issue with that is that many citizens do not have one of the form of identifications that a state with a voter ID law will accept. These voters happen to disproportionately be low-income communities, racial and ethnic minorities, the elderly, and people with disabilities. Many of those in these communities cannot afford or cannot obtain the needed documents to get a photo ID card, such as a birth certificate, proof of residency, or other important documents that are used to prove identity. Currently, these voter ID laws are enforced in 36 states, 7 of these states being ones that enforce them strictly where only certain photo IDs are accepted, while other states will leniently accept a birth certificate without a photo ID. An example of when voter IDs laws have had a discriminatory effect is in North Carolina, where public assistant IDs and state employee IDs were not accepted as a form of ID to vote. A majority of those who held these form of IDs were Black voters. This discriminatory practice was struck down after litigation against the state. Another example is in Wisconsin, where they permit active duty military ID cards, but prohibit veteran ID cards for voting. Lastly, we have the example of Texas, where they permit concealed weapons permits for voting, but do not accept student ID cards. Concerning the 2020 presidential election, we had to deal with the complications of the COVID-19 pandemic. People were given the opportunity to vote by mail in order to avoid having to vote at a local poll. Voters were given the opportunity to vote safely from their homes. The issue with mail-in voting is that the United States mailing system was not prepared for this shift. The US post offices are underfunded and they did not have the resources to handle the extra mail that was to come in from the mail-in ballots. Currently, there are only 8,000 US post offices across the United States to be able to handle all of the mail-in ballots, which were by the millions, on top of all the other administrative challenges due to the COVID-19 pandemic. Another issue with mail-in voting was that each state is permitted to regulate their own elections under the US Constitution. This means that each state was able to determine how the mail-in ballots were to be handled. There was not uniformity across all the states of how the mail-in ballot process was to be handled, bringing about complications to ballots that were rejected or accepted. There were many states that were also just simply not able to afford being able to fund the election in this manner. The federal government attempted to provide aid for these states. However, each state that accepted financial assistance were required to match 20% of what was being offered, to which some states were not able to and thus could not receive financial aid. The result of all these complications is that there were many ballots that were lost by mail, ballots that were mailed in too late to be accepted for the election, and all of this meant that many votes were not counted. Additionally, we had the financial challenges to many states who were not able to afford to be able to adequately handle the shift in mail-in ballots. The shift of using mail-in ballots for the 2020 presidential election brought about many opportunities for voter suppression across many states. In the case of North Carolina, the Republican Party and the Trump campaign attempted to block a 6-day extension deadline for mail-in ballots. The North Carolina State Board of Elections recognized the complications with mail-in voting, so they extended the deadline of when a ballot could come in and still be counted. Originally, any ballots received 3 days after Election Day were to be counted. The Board of Elections decided to stretch this deadline to 9 days. The Republican Party and the Trump campaign opposed this, attempting to force the state to not accept votes that were mailed in late. After an appeal from litigation that resulted from this deadline extension, the U.S. Court of Appeals for the Fourth Circuit decided to allow the North Carolina State Board of Elections decision to stand, meaning that any ballot received 9 days after the election was to be counted as long as it was mailed on or prior to November 3rd. This brings up questions of whether or not it was fair, and considering the COVID-19 pandemic and the complications of mail-in ballots, as the courts did, we can reasonably determine that it was fair and legal to extend the mail-in deadline.
An important case to highlight is Minnesota Voters Alliance versus Mansky. I wanted to highlight the facts of this case. In this case, the Minnesota statute 211B2 prohibits individuals from wearing political apparel at or around polling places, primary and election days. The text of the statute did not define political, so Minnesota election officials distributed policy materials to help identify which items fell within the scope of the law. This case arose when Andrew Kleik, executive director of the Minnesota Voters Alliance, was temporarily prevented from voting at his local polling place in November 2010 because he was wearing a t-shirt with a Tea Party logo and a button that advocated for the requirement of a photo ID to vote. Minnesota Majority, Minnesota Voters Alliance, and Minnesota North Star Tea Party Patriots, along with their association Election Integrity Watch, EIW for short, filed a lawsuit against the Minnesota Secretary of State and various county election officials to enjoin enforcement of the statute as unconstitutional. The parties claimed that the statute violated the First Amendment facially and as applied and was selectively enforced, which also violated their equal protection rights. The question posed in this case is Minnesota Statute 211B2 facially overbroad, thus infringing upon the free speech clause of the First Amendment by banning all political apparel at a polling place, effectively imposing a speech-free zone? This case went up to the Supreme Court, and in a 7-2 decision was for the Minnesota Voters Alliance. The majority opinion was by Chief Justice Roberts. Essentially, what the Supreme Court said is that the Minnesota statute prohibiting individuals from wearing political apparel at a polling place violates the free speech clause of the First Amendment. The court reasoned that the polling place is a non-public forum under its precedents, which means that a state may place reasonable limits on free speech therein. Content-based restrictions on speech must be reasonable and not an effort to suppress expression based on the speaker's viewpoint. So why are we discussing this Minnesota Voters Alliance versus Manske case? Well, it has been an issue that has come up in the 2020 election. Specifically, are Black Lives Matters t-shirts permissible at the polls? Last week, a poll worker in Shelby County, Tennessee was fired after telling people at the polling place that they either had to turn their "I Can't Breathe" and Black Lives Matter t-shirts and masks inside out. Electioneering or engaging in an activity that supports a particular candidate or party is broadly prohibited at the polls. However, specific rules about what voters can say, wear, or display as they cast their ballots vary by state. Tennessee's electioneering laws bar campaign materials that support a specific political party or a candidate or position that appears on that specific ballot. Shelby County Election Commissioner spokeswoman fired the poll worker, stating that Black Lives Matter and I Can't Breathe are permissible as they do not reflect a specific party or candidate, unlike a Make America Great Again t-shirt, which is directly connected with the candidate on the ballot this year.